your visit to PATCON this year. This particular visit, you participated in a constitutional roundtable with two constitutional attorneys, right?
We did.
Publius Huldah and KrisAnne Hall.
Right.
There's a lot of common ground here between you guys and constitutional attorneys, and if people knew what you stand for, which is the Constitution, they stand for the Constitution, what's the problem?
And nullification. They stand for nullification, we stand for nullification. Well, let me just say though, I was greatly disappointed. I thought this was a wonderful opportunity, this constitutional roundtable, to go over some different ideas and to genuinely go over it. And it's a duty for every person at that roundtable, since to the public they're portrayed, myself also is portrayed as an educator. We're going to give you the truth so that we can have remedy and get back to the Constitution. You know, we have a duty to the people who we teach. We have a duty to the people who are at the PATCON to know all the topics out there. We had a duty to each other as panelists. I had a duty to know their positions. They had a duty to know my positions. They should have been able to articulate my decision or my opinion or my position, and then be able to articulate why it is wrong. Whereas I feel all they did was just say, it doesn't exist. It is wrong. But they could, and the logic and reasoning we were having an issue with. And so again, I just think it was a wonderful opportunity to really have something good come out of this. And I think it kind of fell a little flat.
Well, you know, and anytime you get people together, there's always going to be disagreements. Obviously, not everybody's not going to agree on everything. But do you believe there are fundamental differences between you guys that keeps you from working together?
Well, I don't think there's any fundamental difference that would keep us from working together as long as our goal and object is the truth. What happened? How did we get here? And right now the issue is, I think that KrisAnne and Publius are in the position where I was 25 years ago. 25 years ago when I got involved in this, I thought it was the usurpation of the Constitution. Look at these enumerated powers. And I used to teach this. I taught it up to about 20 years ago until I started finding out that, wait, I think there's something underlying here. I used the Senate Report 93-549, which says that, actions taken by the government in times of great crisis have from at least the Civil War in important ways shaped this present phenomenon of a permanent state of national emergency. And so I started looking at the Civil War. What happened here? What fundamental change? And I think the issue that we have is a lot of people, the politically correct way to look at the American Civil War is that it was a moral war. It was a good and moral war that resolved issues that our founding fathers failed to resolve in the Constitution, and so now it's good. My position is that the American Civil War period from 1860 to 1870, that 10-year period, was a political war to overthrow the foundation of our government, of our nation, of this compact, to where originally all power came from the people of the several states in their individual state, and then the federal government was limited with certain enumerated powers, and that Congress usurped that in this time frame to where they became, and they did extend their powers into their power to interject into the affairs of states and their people and things of this nature under this guise of civil rights. And so again, we just got to look at this time frame. Was the war, because again, we focus a lot with Reconstruction. So we've got to look at, well, let me back up. We focus on Reconstruction. Reconstruction, from the federal perspective, was the punishment imposed for seceding, for the cause of the war. And so what you've got to do is say, well, you can't just start at Reconstruction. Actually, you got to go back to the object of the war, whether the war was lawful, whether secession was lawful, whether people have a right to choose, alter their form of government when they choose, and whether all government right comes from consent of the people or whether all government right comes from consent of the federal government. Abraham Lincoln said it at the output, it's a crime for people to choose their form of government. We will dictate it. We will say what you can do. And Reconstruction is just a furtherization or furthering of that position. The federal government has authority. Supreme authority.
Well, I'd like to say a few things on this debate. I think the majority of the crowd, the majority of people out there, they're much more familiar with nullification in the sense that KrisAnne and Publius are talking about, where we take the states that we have and we nullify federal actions and things like this. But they're far less familiar, and this is why I want you to go into a few things in regards to this. I mean, you know, you've got tons of video and tons of other things out there. It's not like, you know, you can't go and look it up already, so I don't want to get really super deep into it. But I want to concentrate on what is the pinpoint thing that that they're disagreeing with you on here. And I feel like it's, well, that may have happened then. I mean, KrisAnne made the statement, it may have said that. You were talking about the Reconstruction Acts, and she said, it may have said that, but it did not do that. And so it seems like, to me, she has this belief that, you know, these things may have happened back then, but the people in today's states have the right to continue on as if nothing happened, or it didn't happen because it was illegal. You know, there's this mishmash of stuff.
The core of this is revisionist history, the politically correct view that what Reconstruction was readmitting the original states back into the Union. So that when they came back into the Union, these are the original states. Our position is no. Well, number one is, you know, how did they get out of the Union? Okay, well, the war was fought over the principle they never left the Union, so they were always in the Union. When the war was over, they were in the Union. But how they get out? Well, they got out of the Union by what I consider to be a new war, an act of treason by the 39th Congress. Treason is enumerated in the Constitution, Article 3, Section 3, and it consists in levying war, and it uses the word against them, and them being the several states. So treason consists in levying war against the several states. Well, what is war? War is when one group of people goes to another sovereign state, sovereign body, and says, we're going to overthrow your laws. You're not subject, you can't create your laws anymore. We're going to dictate to you what your laws will be, and we're going to exercise jurisdiction over your soil to make sure that happens. And that's the Civil Rights Act. The Civil Rights Act 1983, all the Civil Rights Acts, violations, the Title 42 violations, are this exercise of federal authority over the states. And again, it's what are these states? The definition is what is a state? Are these the original states, or are these a new creation state? And it's very simple to decide that. All you have to do is look at who is the state for. Who was the state of North Carolina? Who was the state of Florida? Who was the state of Georgia? Before the Civil War, you're going to see the word freeman in here. The term freeman is a legal, political status under British common law of what the rights of a freeman are. They were the freemen of those states. And if it's the mere readmittance of those states, of these bodies that have a right to self-govern, and all government right comes from their consent, then you're going to look at the post-Reconstruction, the states that are admitted into the state in 1868 as a result of Reconstruction, and say, okay, is this body politic the same? Are these states the same? And you're going to say that it converted to, the word freeman is totally eliminated from there. It's not for freemen. It's for anyone born in the United States, age 21, of whatever race, living here. And you just merely have to put those two side by side and say, is this the readmittance of that? Or is it a new creation? And if you read the Reconstruction Acts, you'll see, the purpose of the Reconstruction Acts is to create a new jurisdiction over which the federal government has authority. And they're saying they have authority over anything that happens in the states. With the 1983 of their body politic that they created. They created this United States citizenship status through the first Civil Rights Act of 1866. And then it was put into the Constitution through the Reconstruction Acts, through the 14th Amendment. This status of United States citizen that has the protection of the federal government. Well, this protection didn't exist prior to the Civil War. And so for my fellow panelists to say there was no expansion of federal power, well, the federal power didn't have 1983, Title 42, 1983 protections of its citizens prior to it. It didn't have the authority to go into states and dictate if a violation was happening. And I think one of the confusions is people say, well, if the federal government didn't pass this, then the states could just violate people and they could do all sorts of things. And you pretty much you're right, but at least you had, today you'd have 50 options. Well, I don't like the way that state, I can go somewhere else.
Sure, yeah.
And what we did is, we're going to say the federal government is going to be this benign, benevolent dictator. We're going to give them all the power to decide. And we see that when we gave that to them, because they're deciding what are the characteristics of their citizenship, this federal citizenship. And they're going to say it is extended to abortion rights. It is extended to who can pray, because we went from the doctrine of justice to foreigners and justice to other people who want the body politic to equality of everyone.
Now, I have to stop you right here, because one of the things Publius brought up was the 14th Amendment. And if you don't like the 14th Amendment and you don't like the 16th Amendment, why don't you just get rid of those amendments?
Pass a new amendment that gets rid of them, or nullify them through the legitimate process.
Exactly. I mean, what would you have to respond to that?
Well, number one is 16th Amendment isn't our issue. It's really the 14th Amendment. That position is stated upon the presumption the 14th Amendment was ratified properly. Now, you got to remember, I'm sitting at a panel with two people who say nullification is the way to go. If it wasn't done constitutionally, it's null and void. We don't have to recognize it. Well, how was the 14th Amendment put into place? Was it put into place by the prescribed method of how do you amend the Constitution in the Constitution? Because if it was done that way, or at least in some semblance of that, it would be lawful, and then her method would be correct. Our position is that the way they passed the 14th Amendment is they nullified states who refused to ratify it, and created a new body politic of people who are loyal to this direction they're going into.
Okay, well, let me stop you right there. If KrisAnne believes in she says, okay, well, that wasn't constitutional, therefore it's a nullity in law. Now, she seems to take it a little further. Because it's a nullity in law, it also didn't do anything and it doesn't exist. I'm not sure how I see that train of thought, but if what she's saying is true and she doesn't believe it's legal, she wants to nullify it, can she? Well, how does that work exactly? How does this? If you believe that a new state was created in this act of Reconstruction, is that correct?
The federal government, a new state, a state being a body of people, a body politic, a new body politic was created by Congress. I mean, if you read the Reconstruction Acts, it tells you who's disfranchised, who can participate. Okay, it changed totally. It said who's allowed to vote, who's not allowed to vote. That's an absolute change. And it said, if you had participated in the rebellion, you can't vote. This is not for you. Well, number one is I'm going back to my original premise of, was this rebellion? Was, trying to have government of right, altering your form of government, a crime? Well, they're maintaining it is. But they're saying, we want people who are loyal to this. And so they created these new states with loyal people. But then they also had to put in there, well, how do we protect these loyal people? And that's the Civil Rights Act. How do we protect these people that are loyal to, and again, a lot of people say, well, look at Abraham Lincoln. He preserved the Union. I mean, don't you think that would have been done? And I'm like, I'm not sure. I'm in favor of preserving the Union at all costs, because that's the Soviet model. The Soviet Union of, once in, you can't get out. We're going to hold you in by force. To me, that violates all the principles of free people, free government, being able to alter your form of government, having government of consent. And so I'm not really big on this union concept that we're required to maintain, or maintaining union was great. So what they did is they preserved the union, this new union, and they put into place, and they created this new jurisdiction, they put into place the tools necessary to where the federal government could enforce their will in the states. And that's through the Civil Rights Acts, 1866, 1871, the 1960s. Okay, these are all extensions of the federal government, extensions of power into the states. The federal government exercising powers into the states that they did not have that power prior to the Civil War to go in there.
If KrisAnne is in favor of nullification, how does she go about nullifying Civil Rights Acts and things like that?
Well, number one is you probably don't want to use them.
Okay.
But I mean, again, I think KrisAnne got into this movement, I believe, through.
You've learned some things about KrisAnne in the past day or so that you didn't know before.
Right. Yeah, and really what it is where did she get how did she enter into this argument of being a defender of the Constitution and things of this nature? And it goes back to she was a prosecutor for the state of Florida, and she was fired because she was going and giving rallies or going to Tea Party rallies and teaching the Constitution and teaching of these usurpations and things of this from her perspective. And she was fired for getting involved in political stuff. So she filed a 14th Amendment Civil Rights Act suit, which is a Title 42 1983 case. I pulled up her case right here. I mean, you can get it online. It's Hall versus Jarvis, and you can see right here it's KrisAnne Hall, plaintiff, and you go right here, the citation, the nature of the suit is Title 42, United States Code, Section 1983. And if you go to Section 1983, you see it derived from the Act of April 1871, which was the Civil Rights Act. These are those Reconstruction legislation.
That was just after Reconstruction.
Yeah, this is the Civil Rights. This is the second Civil Rights Act. You had the 1866 and the 1871.
So she utilized this, which ties in to the 14th Amendment. So
and gave the federal government authority to rule in a state on actions of a state
that should otherwise be
which is
belong
not
to the state.
one of the enumerated powers, which they say the federal government is limited to these enumerated powers. Well, where in that Constitution do they get the authority to come inside the states and rule on rights or wrongs inside that state? They get it from the Act of 1871, these Reconstruction Acts, which reconstructed this nation.
So people might argue that benefited her because it protected her right to speak out, right?
Right, and this is one of the common things is, well, hey, if the federal government, these states can sit there and do mean things. They can do criminal things to people within their states. And I think we're going back to what we just stated a second ago. Well, you're technically right, but that's under the assumption that they will never do anything wrong. Like forcing abortion on us, taking away prayer in school, saying we're not a Christian people.
You're taking your trust from a small level onto a few people that are controlling a large
and all this is under this guise that the federal government's going to be benign and treat everyone fairly. And we see that through all these recent and again, if you go through any of my talks, you'll see I grabbed the landmark Supreme Court cases, and these are extensions of this is the Supreme Court making judicial rulings on application of the 14th Amendment to abortion. Roe versus Wade, all these, we see it in there. And so for their position to be, it didn't happen, it doesn't exist, there is no extra power. Well, you got to sit there and look, did the federal government have any power to rule on abortion prior to Reconstruction? The answer is no. Do they have any power to say we can take prayer out of school? No. Do they have any power to say no state can have the 10 Commandments? No. Do they say no state can, no municipality can pray before it? They had none of these powers. So all of these rulings are extensions of federal power coming from Reconstruction, the 14th Amendment.
So if KrisAnne believes in nullifying these things, why would she use them for her own purposes, I suppose? This would be the question.
You would have to ask her, really, because to me it's a conflict of interest. Because if I'm going to teach enumerated powers, the federal government has no powers outside of what's enumerated in the Constitution. Oh, but I'm going to use this one over here that's not enumerated also, where they have the power to come in the states, and then she can get a very comfortable settlement from that. I think it's a conflict of interest.
That was during the presentation, during the debate, there was an illustration brought up about a car, if your car is stolen. Do you remember how that goes?
Yes, I believe the issue was if your car is stolen. Actually, you can probably say it a little bit better than I. If the issue is comparing the states to a car. If your car is stolen, do the people who stole it get legal title to it, and what do you have to do to get it back? It's yours. All you have to do is go to the authority, say that's mine. Here's my title. I want it back.
But what we would say is that they did steal the car, but we're sitting there pointing at it. There's a person driving it down the road. That's who took it. And by the way, it's a police officer driving it down the road or a government official driving it down the road. And she's saying, no, they're not allowed to do that. And so therefore they're not doing it.
Right. All you have to do is what is their political status? Those people driving the car. Mm-hmm. Are they freemen from that state with that status? Or a direct result of what the freemen did? Because the freemen can change who can vote if it's of their own accord and not coerced. And did they change it to where the United States citizens are residing in the state? Or are those United States citizens riding in that car called your state? And again, merely look at your Constitution. Look at your voter registration application. Look at the Florida voter registration application where KrisAnne is from. You have to swear under penalty of perjury that you're a United States citizen and a resident of the state. The original Constitution, you're required to be a free white man domiciled in the state. Is there a difference between residence and domicile? Courts have ruled the term residence has many definitions. It has many definitions as Joseph's coat has colors. Domicile means, that's where you get all your rights from, is from that state. So originally, to participate in Florida in suffrage, you had to be a freeman domiciled in that state. Now it's a United States citizen resident in that state, and also you can be a citizen of any state you might choose to reside. You can move around. These are not the original states.
Well, I think that seems to me to be the key point of contention, is that are there two different states called North Carolina? I think that's a very heavy topic of disagreement with you guys. And just to wrap this up, I want to put out there that the main purpose of this is not to criticize or demean anyone. I believe it's like you said earlier. We want to go after the truth, and that's what we're all about. And it was unfortunate. It was enlightening, like when you go back and look at the video. But at the same time, it's disappointing that instead of bickering and yelling, that we can't just come together and say, okay, let's have a two-way conversation here. And ask questions. Why do you believe I'm wrong exactly? And I think that's something. When you've got people that are you're all very educated people. Let
me just say this: if you look at the video, you'll see that I'm in constant agreement with them. I'm in agreement with original intent. Absolute. I'm in agreement with nullification. If something's unconstitutional, you don't have to do it. You don't have to recognize it. I'm in total disagreement with nothing has happened. To me, this is that, just pretend nothing's happened. Pay no attention to the man behind the curtain over there.
There's a difference between it being illegal and saying that it doesn't have any actual effect on the people.
It is an actual application. I mean,
sure.
You merely let's just go to the Reconstruction Act. I recommend people do this on their own. What was the intent of the Reconstruction Act and what's in place today? The intent of the Reconstruction Act was to increase the federal jurisdiction into issues of loyal citizens, United States citizens in the states, that it had authority over them. It was I made a little small list here. It was to create loyal governments, not of the original body politics. It was to create a new body politic. It was for the purpose of passing or putting the 14th Amendment into the Constitution, and it was done through military force. And that is not how we change governments in this country. That's called, when you change governments and change body politics by military force, that's called a coup d'etat. We're going to use the military to overthrow. The federal government sent the military into the states to overthrow these state governments and create new ones. And now, I'm saying that's what, if you read the wording of the Reconstruction Act, that's what it did. Now all we have to do is, hindsight's 2020. What is in place? Are the original states in place? Or are these reconstructed states composed of this status created by the federal government in operation? I mean, it's that simple.
Yeah. Well, I think if we were, 1, 2, 3 years after Reconstruction had just happened, our state had just been reconstructed, violations of people's rights and their voting privileges and things like that. If Reconstruction had just happened and we were right there, would we be having this same argument with these guys? That's something you've got to think about. Is the passage of time somehow related to why we're not willing to look that far back? And one thing that KrisAnne had said, I believe, she said it's a first. She says the first act is illegal. You cannot create a power from an illegal source. Right. And that's what you're trying to do, is you're trying to go back, follow this all the way back to the source. It's not, as she said, a blame game. We're blaming this and we're blaming that. We're trying to find the original source so that we have a legal standing to nullify, in order to nullify. And she's saying, well, we can do this from the states that we have. You're saying that state's a new creation. I personally would love to see more conversation on this. I would love to see you guys get together again and have another, maybe a roundtable discussion, maybe heavily moderated, or whatever it takes, to get you guys back together again and talk about some more of these issues.
And I would love that also, because again, there's fundamental. I do want to make one thing is, when I made the statement that the states were overthrown, they were vacated. The evidence of that is look at the surrender letter of Jonathan Worth. I mean, the government was surrendered. I mean, these are original source documents, and then it goes back to their position. Okay, if you go to the original problem and it created power and it was unconstitutional, it has no authority. Well, they did vacate the Constitution of North Carolina for the freedmen of North Carolina. They did vacate the Constitution of Florida for the freedmen of Florida. They did all that. The remedy, the nullification remedy is repopulate the lawful state, not stay on this track of usurpation and think you can correct it inside the usurpation.
In a state with that new Constitution.
In a state with that new Constitution, that new body politic, which gives the federal government authority inside that state to protect its loyal citizens.
Sure. Well, John, thanks for your time. I appreciate you going over this with us, and I hope that we can come together again.
I would love to further this with other people who want to get this country back on a lawful constitutional foundation.